Since I have launched this campaign to repeal the bar exam, several people have argued that the bar exam is necessary as a safeguard against incompetent lawyers in the same way that medical exams protect society from incompetent doctors. Comparing the bar exam to the medical exam is like comparing apples and oranges. First, medical exams are based on facts that have been tested and scientifically proven. Bar exams are subjective. There may be more than one correct answer, but you're supposed to choose the best answer. The best answer is extremely subjective. Bar exams assume that there is only one correct answer. For example, a burglary is entry by breaking into during the night time with the intent to commit a felony inside the structure. A bar exam question may say that John Doe committed a burglary based on the elements of the crime. In reality, John Doe has not committed a burglary unless a jury verdict says he committed a burglary. Technically, the jury is the trier of the facts and not the law. In reality, the jury is the trier of facts and the law. The law is whatever an attorney can convince a jury to agree with. It doesn't matter if all the elements of the crime are proven. If a jury doesn't agree that the defendant should go to jail, the defendant is not guilty. Secondly, if a person can't afford an attorney, he has the ability to research the law and represent himself in court. In fact, 65% of all cases are handled without any assistance of counsel. The same cannot be said for medical procedures. If a man can't afford medical care, he doesn't have the option of performing surgery on himself. Nor does he have the option of writing his own prescriptions. Third, the medical exam is complex because the human body is complex. The legal system is complex because judges and lawyers have made it complex. In most problem-solving professions, there is usually a preference for reaching the simplest, cheapest and most expeditious solution possible. The legal profession seems to be the exception. Judges and lawyers prefer complexity. In the legal profession, complicated doctrines and opinions receive praise while simple doctrines go unnoticed. Bar exams encourage a convoluted legal system because the ability to memorize these complicated doctrines has become the standard of legal competency. Practitioners create complicated doctrines to make a name for themselves. All of this is done at the expense of democratic values of transparency and public access. In a true democracy, laws should be simple enough that any person of average intelligence can understand them. Lastly, the right to an attorney is a fundamental right. Under the Sixth Amendment, citizens are guaranteed the right to counsel in criminal cases, which includes the right to choice of counsel. There is no right to medical care guaranteed by the Constitution. Therefore, the medical profession has more discretion in determining its standards of practice. It is impossible for standards to practice medicine to conflict with any constitutional rights because there is no constitutional right to Medicare.